ICE is getting ready to arrest a whole lot of more individuals. Let's talk about it. Hello, guys. Once more, I am back catching up on some things that I want to bring to your attention. And in this video, we are talking about that leaked ICE memo dated July 8th of 2025. Let's take a look and let's break down what we are going to expect to start happening from here. First off, let me just share with you. One of the first news outlets to break this story was the Washington Post. This article here is by Reason. It's dated July 16th, and the headline reads, Leaked Memo, ICE to block bond hearings for millions of undocumented immigrants, detentions to skyrocket. And then it begins off by saying immigrants who arrive illegally in the U.S. may be detained for months or years as they await a resolution to their immigration cases. And we're only going to read a tidbit of this first paragraph, and then we're going to jump right into the memo and break up in terms of what we can expect from all of this that's happening. This is huge, guys. Now, this article reads, an internal immigration ICE memo sent on July 8th declared that immigrants who arrived in the United States illegally are no longer eligible for a bond hearing as they fight deportation proceedings in court. The Washington Post reported on Monday. The new policy means millions of undocumented immigrants may be detained by ICE potentially for years as they wait a resolution to their immigration case. Now, before this change in policy, if an individual illegally entered the U.S., they could ask for a bond before an immigration judge, certainly if they were not subject to mandatory detentions or anything like that. But let's switch over to another screen. Here we are on the ME policy tracking. This is a immigration policy tracking project site. And so here is the memo, July 8th, 2025, ICE interim guidance regarding detention authority for applicants for admission. And so I've already downloaded it, guys, so we can go ahead and take a look. So this is the memo in full view. Let me put my glasses on so I can make sure I can read it with accuracy for you guys. Let's just read portions. And so this memo is directed to all ICE employees. And it kicks off by saying, right, guidance regarding detention authority for applicants for admission. And then it says, as you all are well aware, DHS, detention authority under immigration laws, is extraordinarily broad and equally complex, right? We would agree that it is complex. And so it goes on to indicate that the department's authority to detain and its authority or lack of authority to release an alien for immigration detention varies upon the circumstances of the case. It goes on to say, this message serves as notice that DHS, in coordination with DOJ, has revisited its legal position on detention and release authorities. DHS has determined that Section 235 of the Immigration Nationality Act, rather than Section 236, is the applicable immigration detention authority for all applicants for admission. The following interim guidance is intended to ensure immediate and consistent application of the department's legal interpretation while additional operational guidance is developed. So, in short order form, this memo is guidance and direction to ICE officers, employees, that undocumented immigrants who entered in the U.S. illegally, right? Who entered into the U.S. illegally, they are no longer eligible for a bond hearing before an immigration judge. And let's go a little bit further down. Custody determination. An applicant for admission is an alien present in the United States who has not been admitted or arrives in the U.S., whether or not at a designated port of arrival, INA 235A, sub 1, Effective immediately. It is the position of DHS that such aliens are subject to detention under INA 235B and may not be released from ICE custody except by INA 212D sub 5 parole. And I'm going to skip this middle portion. Let's go down here. The only aliens eligible for a custody determination and release on recognizance, so ROR, bond, or other conditions under INA 236A during removal proceedings are aliens admitted to the United States and chargeable with deportability under INA 237, with the exception of those subject to mandatory detention. So let's just break that up. So in the world of individuals, right? Because let me just also say, if you were an arriving alien, the immigration judge didn't have jurisdiction over you. But for the folks who came into the country illegally, that are here among us, I should say, that did not arrive and ask for admission, whether or not with a permission, with a visa or non-immigrant visa, those individuals are now the subset of individuals who can no longer go before an immigration judge and ask for a bond as previously. And so what this memo is declaring, and I want to break it up because guys, as immigration attorneys, this is where the legal argument in court is being made, right, before judges. And so what this memo basically breaks down for us, breaking it down for us, is that the memo is now declaring, and I'm looking at my notes over to the left, guys, or my left. The memo is basically declaring that those individuals who entered the country, the U.S. illegally, now must be held in detention by ICE for their entire duration of their removal proceedings. So this is a complete shift as far as prior policy that said, okay, someone who entered without inspection, or someone who snuck into the country and is in the country, but nobody knew that they were there. And let's say if they finally got arrested, that individual could ask for a bond, right? No longer the case. So now the only immigrants who can ask for an immigration bond before a judge are those individuals who were admitted into the country, right? So for example, if you were admitted, you're a visa overstay, and you get a notice to appear to go before the immigration judge, or if you are someone who is a green card holder, and the government is seeking to have your green card revoked or terminated by a judge, and that would be, you would be in deportation proceedings under INA 237. With the exception of those folks, everyone else is subject to mandatory, being detained by ICE. And so that means that it will be ICE, not the judge, immigration judge, that will have any say or control over the release of an individual who maybe before could ask a judge, an immigration judge, for a bond, no longer, based on the memo that ICE has issued to its officers. And so in this circumstance, now what that means is that immigrants can only be released in rare exceptions on parole, and the determination, if so, that's a key word, guys, the determination for those who in rare circumstances can be released if you're detained by ICE under this new policy, that determination is going to be made by ICE and not an immigration judge. And so the memo goes on to provide the justification and the reasoning, right? It's a policy shift. This memo basically is ICE's new policy or interpretation of existing immigration law and how that existing law in the past was interpreted and how that policy was effectuated. So that's a huge shift coming from the administration. And so this is a big deal. This is a very, very big deal, guys, because I've talked about in previous videos that when you are in custody and you are trying to defend your removal or deportation proceedings, it can be very challenging if don't have access to getting your evidence, working with your attorney, gathering your witnesses, and all of these, types of, evidence so that you can prepare. And so this policy that ICE has announced or given guidance to its officers, it's going to lead to much more individuals being detained in ICE facilities. And so what that means is those individuals who previously could ask for a bond before an immigration judge, they now will have to remain in detention, potentially for months or even years. New policy is likely going to face legal challenges from immigration advocacy groups and attorneys who are already, preparing, lawsuits. And so, likewise, this is going to be huge for many individuals. In particular, and this is important, guys, because we've got to put it all together. In many other videos, we talked about, for example, TPS, when it ends, it's going to end. And many individuals who are here in the country with TPS from their designated countries are individuals who are going to come within the scope of this new ICE policy memo because you entered the country illegally. You are, have lived among the citizens and residents of the United States. However, you are not admitted into the United States and you don't have a green card to the United States. So that puts you squarely within the scope of this new policy memo on how the government is now treating such individuals who before could request a bond before an immigration judge, not anymore. ICE is now going to determine any releases, if any, and under what circumstances. So the skinny version, guys, is that the July 8th leaked memo is a huge policy shift that is going to drive more individuals being detained, undocumented individuals who entered without inspection and admissions who are not green card holders. And this is going to remove the ability to seek a bond before an immigration judge so that you can be out on bond while your immigration removal case is pending. And so this is going to have a lot of consequences, because there is currently a backlog of cases in the immigration court system. And so that means if you were waiting for a long time and you were not in ICE custody, if you are arrested by ICE pursuant to this new policy memo, you will not be going before a judge. You will wait out your turn to have your day in court with an immigration judge for a long time, potentially. Guys, this video was for informational purposes to share with you the leaked ICE memo, just so you guys are aware. I do want to say here, guys, particularly for individuals who have TPS, and particularly for many of the Haitian TPS holders here in Florida, whether you're in South Florida, Central Florida, Northern Florida, start preparing. Here in Florida, there are many community outreach information sessions that are sharing information with individuals, because you have to have a plan. And for those who only have TPS, This memo, if you entered the country without admission, then you fall within the four corners of this memo of individuals who are now, ICE will now deem to be individuals who are applicants for admission and therefore subject to detention. So it is important, guys, to work with a licensed immigration attorney so that you can discuss and go over your immigration matter, because change is coming and it's already here. Guys, thank you so much for watching. Please be sure to like, share, and subscribe, and I will definitely see you in the next one. Bye-bye.